This case starts like a routine courtroom hearing, but it quickly spirals into something much darker. An 18-year-old defendant, facing a serious felony charge involving a deadly weapon, stands before the judge, but what unfolds isn't just about legal procedures. It's about accountability, choices, and a shocking moment that turns this entire hearing into a brutal reality check. From plea deals to prison time, and a judge who absolutely does not hold back, this is one of those cases that makes you question, how does someone so young end up here? And more importantly, is justice about to be served or just negotiated? Stay with us, because what happens next will leave you stunned.
Please approach and announce for the record for the state.
Michael Villarreal for the state.
Orlando Castañon for defense.
All right. And are you Sabian? Is it Robles or Rosales?
Robles.
I put the wrong name.
That's okay. And are you Sabian Robles? All right. Counsel, have you received all the discovery in this case, and did you review that discovery with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Robles, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yeah.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor. The state filed a motion to amend the indictment to add a count 2 for an aggravated assault with a deadly weapon.
And we have no objections to that, Judge. We also waive the 48 hours of passing for the indictment.
Right here, things get very serious, and if you're not familiar with legal terminology, let's break it down. The state is amending the indictment to include aggravated assault with a deadly weapon, which is a massive escalation. This isn't a minor adjustment. This is what's called a substantive change, meaning the entire nature of the charges becomes more severe. The judge even pauses to make sure the defendant understands that this could mean 2 to 20 years in prison. Now here's the key moment. Despite being given the opportunity to slow things down and prepare for trial, the defendant chooses to move forward immediately. That decision alone can have life-altering consequences. So let me ask you, if you were in his position, would you rush forward or take every second you could to prepare your defense?
It's not reading down, it's just amended. We have no objections, Judge.
All right. Mr. Robles, do you understand that that amendment to the indictment is a substantive change? Do you understand that? And do you understand your attorney has the legal right to have a chance to prepare for jury trial once there's a substantive change has been made to the indictment? Do you understand?
Yes, ma'am.
All right. Knowing that, do you still wish to proceed?
Yes, ma'am.
All right. And they have the complainant as Michael Villarreal.
That is true, Judge. That is the name of the complaint.
And we waive any potential conflict.
All right. And so I'm assuming that's not you, Mr. Villarreal.
It is not, and it is somebody that I am not related to by knowledge.
Okay. All right, Mr. Robles, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand with the amendment to the indictment, the state is proceeding on aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand? I'm sorry. Counsel, has your client been able to provide you with any defenses to this offense?
Yes.
Now, we're seeing the plea deal come into full focus, and this is where strategy meets reality. The defendant agrees to 4 years in prison, a $1,500 fine, and an affirmative deadly weapon finding, which is extremely significant. That last part isn't just a label, it can affect parole eligibility and follow him long after he's released. Also notice this, by accepting the plea, he's giving up major constitutional rights, including the right to a jury trial and the right to appeal in most circumstances. That's a huge gamble, but also sometimes the safest option when the evidence is strong. But here's the bigger question: is this a fair deal? Or is this the system pushing someone into accepting punishment just to avoid something worse?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Robles, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargaining agreement? Are you satisfied with the way you've been represented?
ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count 2.
And this is where everything shifts from procedural to deeply personal. The judge is no longer just reviewing paperwork, she's confronting the defendant directly about his actions. What stands out here is the emotional weight behind her words. She's not just sentencing him, she's calling out behavior that goes beyond the legal charges. The mention of bullying and targeting someone vulnerable, possibly autistic, changes how this entire case feels. This isn't just about breaking the law, it's about morality, character, and consequences. You can hear the frustration in the judge's voice. She's trying to make him understand something bigger than the courtroom. But the real question is it too late for that lesson to matter?
Only. Punishment is to be assessed at 4 years in the prison. There's a $1,500 fine. There's an affirmative finding of a deadly weapon. There are no applications, and there is to be no contact with Michael Villarreal. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Judge.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Then to count 2 in the amended indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. At this time, state offers State's Exhibit number 1 and its attachments.
No objection, Judge.
Mr. Robles, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge. We just asked if you followed this plea agreement.
All right, what's wrong with you?
Give me what time, please.
I don't understand.
This moment is absolutely chilling. The judge lays out the harsh reality of prison life, not to scare for drama, but to make a point about consequences. She draws a direct line between the defendant's actions and what he might face behind bars. And whether you agree with her approach or not, it's undeniably powerful. What's also striking is how she shuts down excuses. The defendant's background, his past struggles, none of it justifies what happened. The judge makes it clear, at some point, your actions are your responsibility. And this is where viewers are divided. Some will see this as tough but necessary truth. Others might feel it crosses a line. So what do you think? Is this justice being served, or is this too harsh?
When people go to the Bexar County Jail or they're in custody, people are just trying to serve their time. That doesn't give you any right to be a bully. You understand?
Yes, ma'am.
So again, I'm asking you, what is wrong with you? Why would you pick on someone?
No, ma'am.
Have you ever heard of the song Leroy Brown?
No, ma'am.
In those lyrics, Leroy Brown is the baddest man in the whole town. And you know what ends up happening to Leroy Brown?
No, man.
He looked at the wife of a jealous man, and everybody was afraid of Leroy Brown. But then you know what they said at the end? That guy got in a fight with Leroy Brown, and Leroy Brown looked like jigsaw puzzle with many pieces gone. So when you bully people, guess what? There's always some bigger bully out there. There's always somebody else who can beat you. And I want you to realize people are just trying to live their life. They're hoping that they don't have to deal with nonsense from you and nonsense from other people at the jail. When people go to the Bexar County Jail, guess what? They're just there to serve their time. And we are not in a society of savages where people are supposed to go to the Bexar County Jail to get beat up and harassed. They're just there to serve their time. If we were living that type of society, guess what? We wouldn't have a jail. People would just handle their business on the street. And what you did to this individual with help from others was cowardly and it was wrong. Do you understand?
Yes, ma'am.
How old are you?
18.
When are you going to get your life together? Because right now you're going downhill. No, it's not okay. You are going downhill. You're before me and you want me to give you 4 years for an aggravated assault with a deadly weapon when it really should be a sexual assault case because you want to do crazy things at the jail with inmates who are just trying to serve their time. And then you pick it on somebody I read in here who may be autistic. And then you're not even brave enough to do it yourself. You get other people to help you. And then you're saying someone told you to do it. And that's silly in and of itself. And now you're going to prison for 4 years.
Just when you think it's over, there's more. Now, we're seeing a separate issue: violation of probation conditions from a previous case. This adds another layer to the defendant's situation, showing a pattern rather than a one-time mistake. Failing to report consistently might sound minor compared to the main charge, but legally, it's a big deal. It signals non-compliance with court orders, and that can quickly escalate consequences. The court ultimately agrees to a deal here as well, sentencing him to additional jail time. When you stack this on top of the earlier sentence, it paints a clear picture. Repeated poor decisions are compounding into serious consequences.
Do you want to be picked on in the prison?
Yes, ma'am.
Do you want to be picked on at the prison and bullied at the prison and beat up at the prison and maybe raped at the prison?
No, ma'am.
Well, if I don't wish that on you, but if that happens to you, then you need to be thinking about what you did to this person. You understand?
Yes, ma'am.
Where are your parents?
He's has an adoptive mother, and I believe he's just recently had contact with his biological father.
My biological mother.
And I'm going to tell you what I tell everybody. People come to me with sad stories all the time. At some point, your actions are your own. They're not to do with your past because everybody's had a hard life. I've had a hard life. I'm sure your attorney's had a hard life. State has had a hard life. People in jail done had a hard life. So at some point, the actions that you take are your actions. And it's not because I'm from a broken home or I've been adopted or I went to foster care. Do you understand?
Yes, ma'am.
All right. This is what the court is going to do. 4 years prison, affirmative finding of deadly weapon. There's a $1,500 fine. Time and money will not run concurrent. There's to be no contact with Michael Villarreal. I don't know how they're going to do that at the jail, but if you could make sure, I'm sure there's some kind of system to make sure he doesn't have any contact with him. And do you have any siblings?
Yes, ma'am.
How would you like somebody doing that to them? Exactly. How would you like somebody doing that to your mom or your father? Exactly. You wouldn't want that. Is there anything else with sentencing?
Judge, he just has an MTR that I think we need to resolve with the court.
All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
No.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
This case is a powerful reminder of how quickly things can spiral when poor decisions stack up. What started as a legal process turned into a deeply emotional courtroom moment with a young defendant facing years behind bars, not just for the crime itself, but for the mindset behind it. The judge didn't just deliver a sentence, she delivered a message about accountability, consequences, and the reality of the system, from accepting a plea deal to facing additional penalties for past violations. Every step in this case shows how critical each decision can be. And at just 18 years old, the weight of those decisions is now very real. If you found this case as shocking